Welcome you all to the lecture series on corporate law. In the present lecture, we will be discussing on the basic concepts of the charge under the Companies Act, floating charge to the fixed charge. It is also called as crystallization of charges. And I also try to find the new nomenclature for this particular subject as the creditor and debtor behavior. What is this creditor and debtor behavior? Let us have a simple example. Say for example, X Limited company, right, borrows money from, say for example, ABC Bank or DEF Bank or maybe the other parties. When the company borrows the money, right, if the company borrowed the money, you are having here one person as the lender, it is the borrower. So when you see the lender and borrower, the other names what we can have for these same people are a creditor and the debtor. So if the creditor who lended the money has a right to recover the same in the case of the default as provided under the a proper instrument, right? So to understand in a simple way, as long as debtor repays the money which is borrowed from the creditor, there is no dispute at all. In the case where the debtor pays some partial money and not paid complete money, and sometimes the creditor wishes to realize the money on the maturity date, sometimes even before the maturity date, as per the terms of the contract. Now here brings a subject of charges, otherwise I call it as the law relating to the creditor and debtor behavior. Now let us see what is this meaning of the charge as per the Companies Act. Companies Act 2 clause 16 talks, charge means an interest or lien created on the property or assets of the company or any of its undertaking, and also includes the mortgage. Though under the Indian Transfer of Property Act, mortgage does not include the charge, whereas in the Companies Act, in the definition of the charge, mortgage is also being included. So it is the interest or a lien created on the property of or assets of a company or any of its undertaking or both as a security and also include the mortgage. Now if you see the historical or the origin of this particular terminology, it is a right given to the a right given to another by the owner of the property to secure a debt or one created by the law in favor of certain creditors. A lien is an encumbrance on one's property to secure a debt of the property owner, right, to secure the debt the property owner owes to another property. I will repeat again. A lien is an encumbrance on one's property to secure a debt the property owner owes to another person. The statement that someone's property is tied up describe the effect of lien on both real and the personal properties. Lien is basically a French term meaning thereby not or binding that was brought to Britain with English with the French language during the Norman conquest in the 166. So lien is a right to retain lawful possession of another piece of property. So, lien means possession of property by virtue of law. So, the possession of the property is held by somebody else, and there also talks about the fulfills about the legal duties. So, payment of the charges, etc. and all. So, in a simple understanding, when there is a transaction between the company as well as to the third party, and they keep the agreements between the borrower and debtor, and in the agreement between a borrower and debtor, the properties are kept as a security. When the properties are kept as a security, then the whole issue of the rights of the debtor and creditor comes. Let me again clarify myself. I will be discussing in the lecture initially the provisions of section 71 to 77 of the Companies Act 2013 and followed by another analysis. Now, chapter 6 of the Companies Act, which talks on charges, where it discusses it is a duty of every company, right? It is a duty of every company creating a charge within or outside India on its properties or assets or any of its undertaking, whether tangible or otherwise, and situated either in India or outside India, to register the particulars of the charge signed by the company and the charge holder together with the instruments, if any, creating such charge in such form on payment of such fees and in such manner as may be prescribed with the registrar within 30 days of its creation. Some of you may say that, sir, what is this language? I am just verbatim reproduction of the language of section 77. So it is very simple to understand. If the company borrows the money by keeping its property as a security and also created a charge, it has to submit to the registrar of the companies, a registrar, within 30 days of its creation. So that is the first requirement under 77 is that is a duty of the company inform to the registrar that so and so property or on so and so property a company has created a charge. I given a simple example. Say for example, X Limited company is having plant A, plant B and plant C. It has 3 plants. One is in India, then other one you can say UK and some other countries. If the lender has given a money, keeping these properties as a security, the company has to inform to the registrar, right? Company has to inform to the registrar stating that on these properties charge is created. So therefore, the further people or the people who are going to create furtherance of any charges, they will come to know that charge is already created. And also, the registration of a charge will also qualify certain rights, right? The registration of the charge will also qualify certain rights where the parties can claim and also the parties can also raise before the court of law. That is the point number 1. Point number 2 is that where the charge is registered with the registrar under subsection 1, he shall issue the certificate of registration as formed and has been created. So this provision we don't require. So we may have the Bare Act. You can read as and when you get a time. So the important concept is that the charge has to be registered with the registrar. And subclass number 4, nothing in subsection 3, right? Nothing in subsection 3 shall prejudice any contract or obligation for the repayment of money secured by a charge. So what is there in subsection 3? Subsection 3 says, notwithstanding contained any other law for the time being in force. These phrases you find in the legal text. Legal text in sense, notwithstanding anything contained in any other law for the time being in force, no charge created by company shall take into account by the liquidator or any other creditor unless registered in subsection 1. So, it gives a right to the creditor and the liquidator only where it is being created as the registrations. Even though it says so many things or various other laws are provided. So, the registration of the charges qualifies certain rights, and also the registration of charges will also provides different mechanisms, different rights. This lecture I will be talking basically with regard to the company law, because the law on the charges comes under the Companies Act, Transfer of Property Act, DRD Act, Surface Act, and other allied legislations. I would be confining to the chapters on Companies Act. When you start practicing of this subject, because this is one of the very prominent chapter, very prominent practical subject where everyone has to understand. And section 78 talks for the application for the registration of the charges. So basically it provides where a company fails to register the charge within a period specified in section 77 without prejudice to its liability in respect of any offence under this chapter, the person in whose favour the charge is created may apply to the registrar for registration of the charge along with the instrument created. As for the time is given, is a time factor. So the time is provided and where the company has to register and it has to make the application. Section 79, it applies to the acquiring of a property. So section 79, the provision of this section 77 relating to registration apply to a company acquiring of any property subject to a charge within the meaning of this section. Registration of charges to be kept by the registrar is as simple and it can be understood in a simple language. Once the company register the charges, the registrar of companies would keep the register of charges. Therefore, the people who are giving as a second or third loan, they can see the document how many times a charge has been created on the same properties. We will discuss what is that same property in the next another 2 to 3 minutes. And company to report the satisfaction of the charges. So again the company has to inform to the registrar about the charges. Power of the registrar to make the entries of satisfaction and release in absence of intimation from company. So it is also a duty of the registrar to inform to the court or also the other register holders about the property when the property is being created or when the property kept as a security where the company borrows the money. Now this is a very important provision. Intimation of appointment of receiver or manager. If any person obtains an order for the appointment of a receiver or a person to manage the property subject to a charge, such receiver or a person under any power contained, he shall within a period of 30 days from the date of passing of an order making the property. So let us make very simple. If X Limited company borrowed a loan from ABC Bank and there is a default, the property is plant B, which is a secured property, and court appointed receiver to recover the property. In that case, then the receiver, right? This receiver has a right to sell this property or to recover this property on the mechanisms, various methods which are created under the legal provisions, under the legal mechanisms. Certain legal mechanisms and legal methods. There is a sale of the property. There are also moratorium agreements. There is also insolvency process and the SURFACE Act. You have the various legislations which provides rights for the creditor to realize the money which was given to the debtor in the case of the default. Because in the legal process, always creditor wishes to realize the money. Debtor has to pay the money, there is no doubt. As per the law, debtor is supposed to repay. But in the case where the debtor takes an advantage, right? Where the debtor takes an advantage of the legal proceedings or the judicial process to evade the liability or to make the judicial process not to repay immediately, then the whole litigation will come. The whole process of the legal proceedings come into the existence. Section 84 comes with regard to the appointment of receiver or the managers. And Section 85, every company shall keep its registered office, right? Shall keep its register office a register of charges in the form as may be prescribed, which will include all charges, including floating charge. Here only you find what is the floating charge. There are different types of assets, particularly tangible asset, intangible assets, and there is also one of the assets called a floating asset. Like for example, stock in trade. Then other one is uncalled share capital. These are a floating assets, right? If a charge is created on the floating assets, we call this as floating charge. So floating charge in a simple meaning is that a charge is created on the assets which are in the floating nature. When the assets are in the floating nature and these assets are to be crystallized in the case of the default, that is where we call it as crystallization of charges, and also otherwise called as floating charge, right? Floating charge becomes fixed charge. So basically the difference of floating and fixed charge, it changes from the nature of an asset, nature of the property which has been created. Don't get so much of confusions. It is as simple as that. When assets are being classified in the nature of the floating as well as in the nature of the fixed. So depending upon the nature of an asset, we call it as a floating charge, and the floating charge becomes a fixed charge on happening of an event. On happening of an event basically called as the default. On happening of an event may also comes under the on maturity date, or because of the default we call as a floating charge. So only you find under section 85 the terminology of the floating charge where it has been reference has been made in the Companies Act. For this we have one of the oldest case, Panama, New Zealand and Australia Royal Mail Company case. In this case, there was a steamship company. It has a power to issue the mortgage debentures, and it also created the charge on all undertakings. Now the question which came in this case was that whether undertaking can be called as a property, and the court has said in the Australian courts, the properties or the meaning of the property includes undertaking also, and in this case it was also held that the debenture holders therefore have a charge upon all the property of the company, past as well as the futures. Some of you may have a doubt, what is this future property? I give a current example, stock in trade. Stock in trade, where the stock is in the market, the complete value comes in the future date. Even the case of uncalled share capital, the value of the total property comes on realization of a particular event. So try to understand the properties which are there in the present, the properties which were there in the past as well as future. You can create a charge and all charges becomes equal. The other one is characteristics of the floating charge. Charge upon the class of assets, both present and future. Just I have given example for the present and future. The example which you can have the stock in trade, uncalled share capital, which is existing even present as well as in the future also. Then class of asset charged in the ordinary course of business. Generally when it happens, ordinary course of business, basically the stock of trade. Then for this you have another example also. State of Andhra Pradesh versus Raja Ram Janardana, where the court explained the difference between floating and fixed charge as well as crystallization of charges. So the court explained about in elaborate manner the differences on the crystallization of charges. Crystallization of charges, what we call it as when the floating assets become a fixed asset, so automatically we call as the crystallization of charges. Pari Passu charge is another concept which is very prominently used in the chapter of the debentures. Here I will try to explain a small example. A limited company has property A, value rupees 100 crores, right? A limited company has property A, value rupees 100 crores. It has borrowed from Mr. A 10 crores on, say for example, 1st November 2022. From Mr. B again 10 crores on again 1/12/2022. From Mr. C 10 crore rupees on 1/1/2023. The simple example is that on the same property, 3 persons or 3 companies lended the money on different dates. Number 1, number 2, number 3. Where a charge is created on the same property at different point of times. In the case of the default, these 3 people are having the equal right. So equal, otherwise we call in the legal language, is Pari Passu. Unless expressly there is a provision in the agreement, the charges which are created subsequent to the first charge, that's what the legal language says, the subsequent charges created on the same property will have the same as well as equal rights. So this is what we call it as Pari Passu charges, and sometimes also floating charge, also the fixed charge. And this movie has been already viral and also become removed from the Netflix. These are all the great directors of Indian corporate sector. Some of the people are being punished for borrowing of money from the banks. They left India. Some of the people are still facing the judicial process. We call this legislation into the understanding of what is called about the CDB, that is called creditor and debtor behaviors. So because today there is a huge development of creditor and debtors behavior, to identify the logic of creditor and debtor behaviors, there is new legislations which have emerged. Like if you see the whole subject of the creditor and debtors, initially we have the CPC, then we have the DRD Act 1992, followed by Surface Act 2002. Now we have the new legislation IBC 2016. So the various legislations came into existence to identify or to bring the liability of the borrower or the debtor, that the borrower or the debtor should repay the money as agreed or as determined in the agreement. Therefore, the creditor will not have any problem and money will not be struck in the capital markets. Money will not be struck in the domain of the corporates, because when the corporates takes huge amount of the loans, crores of loans from the banks, particularly nationalized banks, where the banks acting as the creditors, where the debtors are not repaying the money which has been invested in the different sectors, and they take an advantage of the legal or judicial mechanisms. Sometimes they want to repay immediately, sometimes they don't want to repay, and they also use the tools which are available in the manner of rights of the debtor and creditor provided under the various legislations. To put it a simple understanding of this particular lecture which I try to inform, a charge which is created under the Companies Act has to be registered with the registrar. The registered charges have a right at the time of when the receiver is appointed, as a time when the liquidator is appointed. The registered charge holders always have a priority right than the unregistered charge holders. The registered charge holders always have a priority right than the unregistered charge holders. Pari Passu charges and crystallization of charges, generally the short notes questions which you get in the BA LLB examinations or any examination, this is one of the standard question where you find that the difference between the charges as well as the meaning of the charge. Though the charge has been defined in the Companies Act, but the Transfer of Property Act has a different definition. No need to get confused, but that's what I put it in my slide, the behavior of the creditor as well as the debtor behaviors. So I will pause my lecture here. In the next lecture, we will continue in some of the new topic. We will discuss some topics of the corporate law. So thank you for patiently listening. If any one of you are unable to get the clarity on my lectures, you can write in the comments. I will try to elaborate on the comments. I will try to clear your doubts in further lectures. So thank you. Take care. See you. Bye.